Well, hey, good morning, everyone. Thanks for joining us on a beautiful Friday morning here in Minnesota. Great to have everybody with us to talk about some of the new and recent warehouse laws affecting warehouse operators here in Minnesota. I'm Bruce with the Minnesota Retailers Association. Today, we're going to be covering a core piece of the Warehouse Worker Distribution Safety statute that passed this past year and is in effect right now, including quotas and written descriptions, work speed data, high rates of injury investigations. We'll also be covering some safety committee changes, how the department will look at enforcement of these measures, and then a few other bonus things here, a couple things that some of you might not be as aware of. One of those is the National Emphasis Program for the warehouse industry, and we'll be talking a little bit about ergonomics and, of course, timelines for implementation. So we appreciate everybody joining us today. Just a couple of program notes. We are recording today's webinar. Hopefully you got that notice. So we'll send you the link around if you missed something during today. We'll make sure you can catch up on that. Also, just a big thank you to partners that have partnered with the Retailers Association on this webinar, including the Minnesota Grocers Association, the Minnesota Trucking Association, the Minnesota Beverage Association, the Minnesota Chamber of Commerce, BOMA of Greater Minneapolis, the Minnesota Agri-Growth Council, and of course our friends at OSHA as well. So we appreciate everybody's partnership on this and willingness to get the word out relative to these changes in law and what we can all do to comply and keep our warehouses safe. Just a quick program note, protocol for questions today. We can field questions throughout. You're welcome to open up your microphone at the end if you'd like. Otherwise, feel free to put questions in the chat. You can put those in the general chat for all to see, or you can direct them directly to me, Bruce Newstead, and we'll make sure those questions get asked as well. With that, I think just one other quick note. This is Zoom, so you actually have the ability, of course, to control how you see the screen. Right now, you should see the Warehouse Worker Distribution Safety slide. I'll try to keep you all muted until you unmute yourself during the presentation. But yeah, you should be able to control how you view this if you like as well. With that, I won't delay any longer. We will get Ron Anderson up. Ron is Health Director of Minnesota OSHA Compliance. Ron's actually a 25-year veteran of the department, so he knows this stuff inside and out. Ron has been, like I said, with the department for about 25 years, but prior to that had previous experience in the private sector as well. So with Ron, please accept our gratitude for doing the webinar today. We look forward to hearing your information, and go ahead and take it away, Ron.
All right, thank you, Bruce, and welcome everybody. As Bruce indicated, I've been here for a while at Minnesota OSHA, so while I know some things, I never claim to know everything. And as Bruce and I were discussing earlier, some of the stuff we received this information around the same time here this spring. So hopefully you guys have been working to take note of some of these things as we have here, and we'll talk about it here together, and we'll go forward together with this stuff. So as Bruce indicated, please feel free to put questions in. We'll try and take them as it comes. If it's pertinent to the discussion, we'll take them as we go. If it gets to be too many, we'll try and get through the material, and I'm happy to hang on to the end as long as people want to ask questions. So we will work our way through that. So with that, I'll actually jump back here for a minute. Just as Bruce said, I am the health director here at Minnesota OSHA. So from a traditional OSHA standpoint, that has meant that I am responsible for our industrial hygiene or health investigators here. So with some of the new things that the legislature provided for us this spring through Ergonomics and the Warehouse Distribution Safety Act, those have fallen to me as well. So I am working to kind of head up a group that is going to participate in the enforcement, the outreach, and those types of things. So that's how I got to be here today. And so Bruce kind of went through the agenda. It was in the invite, and we're going to jump in just with some definitions. These are new to everybody. These came out in the actual act. This isn't something OSHA wrote, but this is what we have. And we've got a couple of them here. Aggregated employee work speed data and employee work speed data. And employee, is specific to an employee. That's one employee, what they're doing. However, you're tracking whatever information you collect, store, analyze, or interpret related to an employee's performance. Aggregated data is the compilation of all your employees' work speed data, multiple employees in some type of summary form, so that individuals aren't identified. But really, I think we're looking at this as a comparison tool, right? How is one employee doing to the aggregate? Realize as we go through here, much of this statute centers around quotas, written descriptions, and that type of thing. Nothing in this statute states that you need to use a quota. Okay, you don't have to have a quota. If you don't have a quota, you don't have to collect this type of data. But if you do, the statute now says that you have to find ways to collect, store, analyze, interpret, compile this data. And we'll talk about when you're going to need to provide that here as we go. Who's an employer? We've gotten a lot of questions over this. Is this me? Is there a way I can make this not be me? An employer, somebody with 250 more employees at a warehouse distribution center. We're going to define warehouse distribution center in a minute. So one site, 250 or more, multiple sites in the state with 1,000 or more. Okay, pretty clear. Everybody wants to know who's included in that count. My short answer is all your employees. Okay, that's not a technical term. If you want a technical term, you can look up the definition of an employer's unitary business, which I believe is out of a revenue code, section 290.17, subdivision 4. And that's what they've pulled into this statute, and you can look through that. But we do want you to count salary, non-salary, exempt, non-exempt, temporary, part-time. We're counting all. So that's how we get there. You can read through the unitary business definition and decide if you can leave somebody out, but we're going to count them all. And I kind of think that's the whole point of the unitary business is one unit. So I've looked at that. It's not a plain language document. It's pretty technical, and it's not out of an OSHA statute. It's something that was pulled in. So 250 more at one site, 1,000 or more throughout the state. Okay. Let's talk about who's an employee. Okay, we just talked about who's an employee, right? 250 more, 1,000 or more. I'm saying all. Now, and that definition of employer comes from subdivision 1. As we move through the statute, subdivisions 2, 3, 4, employee changes a little bit to non-exempt, performing warehouse work on the property of a warehouse distribution center, does not include a non-exempt employee performing solely manufacturing, admin, sales, accounting, human resources. And I think one of the important words there is solely doing that. So if they're doing some of this and some of that, it's not solely the manufacturing, and the driving to or from. So look at that, and this, the purpose, subdivisions 2, 3, and 4 are going to be, we're going to talk about those as we go, but that gets into more of the quotas and things like that. So if they're, again, performing a job that's not under a quota, or they're doing, not doing warehouse work, as they say here, they'll be exempt from those subdivisions as we go. So look to those. But for the purposes of determining how many employees you have, again, that's back in subdivision 1. That's all. That's exempt, non-exempt, that type of thing. So let's jump to what is a warehouse distribution center. If you're not familiar with North American Industry Classification System codes, commonly called NAICS codes, these are used not just by OSHA. They're used by a lot of regulatory agencies. They're used by a lot of other governmental agencies to identify what industry you're working in. It's used for statistical purposes. It's probably used for things like insurance or other purposes as well. I know these NAICS codes are reported to DEED, the Department of Employment and Economic Development, and likely revenue and some other places. And they're actually created by the U.S. Census Bureau. Okay, so it's not an OSHA thing. We're going to take a look at what you do, what your business is, and we're going to look at the descriptions for the NAICS codes that are listed on the screen. And we're going to say, yeah, that seems to me to be the work you're doing. And we're going to make that best case for where we think you are. Some people are, have made the claim, well, I don't think that's us. We're a retail store. Okay, well, a retail store isn't in there. But you got to look at the definitions and where does your revenue come from, where are your activities, and all these different things. And it's not an OSHA system, but it's out there. And if you're new to NAICS codes, you might want to ask around in your within your company, because somebody likely has already chosen your NAICS code and is reporting it to insurers or other government agencies and things like that. And so really not appropriate to have different NAICS codes for different reporting systems. It's meant to be consistent. If you're not familiar, look at item 2 on the screen where it says 423XXX. These are typically 6-digit NAICS codes, so there might be a 423 100, a 110, a 120, a 130, something like that. XXX means all of those. Anything after 423 is included. Anything after 424 is included, and some of the others are more specific. They're listing out the full 6-digit NAICS code, 493110, general warehousing and storage. So if you're in one of those with an XXX and you're not sure if your specific NAICS code is in there, that's what the XXX means. We're including you. And so as long as you start 423 or 424, yes, you're included. So quotas. A quota is defined, again, we're in a definition, a work standard. I didn't make this definition. You can read it as well as I can, but it's an employer group of employees assigned or required to perform at a specified productivity speed, perform a quantified number of tasks, handle or produce a quantified amount of material, perform a certain number of, without a number of errors or defects, as measured at the individual or group level within a defined time period, or actions that are categorized and measured between time performing tasks and not performing tasks. And the employer's failure to complete a task may have an adverse effect. We're going to look at what are you doing, how are you measuring, those types of things. And so that's what the statutory definition of a quota is. Now we get into subdivision 2. We're out of definitions now. This is part of the statute that we've been given that requires an action. Each employer shall provide to each employee a written description of each quota to which the employee is subject, how it is measured, quantified number of tasks to be performed or materials to be produced, or whatever they're doing must be specified, and any potential adverse employment action that could result from a failure to meet the quota. What are you going to do if they don't meet the quota? Written description must be understandable in plain language and in the language identified by each employee as the primary language of that employee. So that way we know they understand it. They understand what they're being held to, what they're being measured to. So that's something that you have to do. If you're using a quota system, you must provide to each employee that written description of their quotas in plain language, in a language that they understand, their primary language. Must be provided upon hire or within 30 days of the effective date of this section. This section was effective August 1st. So we're getting into that September 1st time frame. So we need to get those quotas out to those people. No fewer than 1 working day prior to the effective date of any increase in an existing quota, and no later than the time of implementation for any decrease of an existing quota. Okay, so if you're going to change these quotas, and I understand that quotas can change, but we need to stay in communication with that employee, and we need to update that we're changing that quota and what's happening with that. The statute goes so far as to say an employer shall not take adverse employment action against an employee for a failure to meet a quota that has not been disclosed. Okay. Now I have a note in here that that's not enforceable under Minnesota Statute 182. Doesn't mean it's not enforceable at all. Minnesota Statute 182 is the authority that's given to Minnesota OSHA. So this is likely going to go to our labor standards group in the department. And they are the group that deals with things like wrongful terminations and adverse actions and child labor and wages and hours and breaks and things like that. So this is not enforceable under Minnesota Statute 182 with OSHA. We work in the same department with these people, so if we hear about it, we're going to make sure it gets into the right hands. But this wouldn't be enforced under our OSHA statute. But at the end of the day, if you use quotas, if you performance manage your employees through use of a quota system, you need to provide them that written description, and you need to let them know when that changes. So, breaks, subdivision 3 of the statute. Employee shall not be required to meet a quota that prevents compliance with their meal or rest or prayer periods or restroom facilities, including reasonable time to travel to and from a restroom as provided under Section 177. Again, that's not 182. That's not Minnesota OSHA. This is our labor standards group. And an employer shall not take adverse employment action against an employee for failure to meet a quota that does not allow them to comply with meal or rest or break periods. So this is in here as a reminder, but it is actually going to be enforced under Section 177.253. What this tells me and should tell you is that this was not allowable prior to this statute either, right? We've had Statute 177.253 in effect that ensures that employees get meal, rest, prayer breaks, use of restroom facilities, that type of thing. This wasn't allowed then. This isn't a change now. They're just drawing this to the forefront while they're getting a little more specific about this quota system. So keep that in mind. Think about that again. Wouldn't be an OSHA citation, but right on the floor below us is our labor standards folks, and we're going to get them what they need to know through that. So, employee work speed data. So you've notified your employees that they're subject to a quota. Failure to meet that quota could have adverse effects on their employment. That's what we asked you to do in subdivision 2. They have the right to request that information from their direct supervisor or another point of contact, and the employer within 4 business days shall again provide to them the written description of their quota, a copy of the most recent 90 days of their work speed data, and a copy of the most recent 90 days of the aggregated employee work speed data for similar employees at the same work site. This is so the employee can see how they're doing, right? You've got them under a quota. They could have an adverse event if they fail to meet it. How are they doing in comparison with their peers, in comparison with the quota that you've subjected them to? So again, the most recent 90 days of data. An employee may make this request under this paragraph no more than 4 times per year, essentially every 90 days, every quarter. They can ask for this data, and it needs to be provided to them. If you're going to track them on this, they have the opportunity to track themselves against their quota and against the other employees that are subject to that same quota. So, if an employer is going to discipline an employee in some way for failure to meet a quota, the employer must, at the time of that discipline, provide them with a written copy of the most recent 90 days of their work speed data. Okay, so that you're disciplining them for this, that should be included in the discipline. What did they fail to meet? If an employer dismisses an employee for any reason, they must, at the time of firing, provide the employee with a written copy of the most recent 90 days. An employer shall not retaliate against an employee for requesting data under the supervision. We want employees to know where they're at. We want them to know how they're performing. There's no adverse action for them for requesting it. Discipline, they had to put a definition in here. A discipline, a formal action documented in writing, and does not mean conversations surrounding performance improvement or training. An employer must formally document any disciplinary action. We want them to know they're being disciplined. So it's not that verbal training, coaching, something like that. It's specified here that it's going to be a formal action documented in writing. So,
hey, Ron, can I jump in with a question here on your second bullet point there?
Sure.
Can you give us a little bit of a sense for how the department will approach kind of an employer's good faith effort to provide that written notification? Sometimes an employee will leave their employment and the employer might not see them again. So just curious how you'll approach sort of what's an employer's good faith effort to provide that in writing?
Well, if the middle bullet on the screen, if you're talking about dismissal,
correct, yeah.
I wouldn't read that to be an employee choice to leave employment. So if an employee quits or doesn't return of their own accord, I don't know that you're obligated under the statute to provide that. If the employer is going to dismiss that employee, I would suggest having it ready at the time of dismissal and giving it to them in case you don't see them again.
Got it.
That's the way I'm seeing that in my head. If an employee quits, I don't see that as dismissal.
Okay, got it. So maybe just a little deeper into that example, say an employee is dismissed for not showing up for work for several weeks as an example, so you don't actually see that employee again. What would be the kind of the recognition of a good faith effort to provide that in a written? Just 1 second, Ron.
All right, I got it.
Joel, we're going to try to mute you here. There you go. Thanks. Okay, go ahead.
I would say a good faith effort is, we're going to reach out by phone, say it's available. If we have email addresses, if we have a home address, you could mail it, that type of thing. If they don't want to call you back, if they don't want to come get it, if they, obviously if you mail it to them, they have it and they can choose whether to open it or not. That's up to them. Those I would consider pretty good faith efforts for getting that to them.
Great. Thanks, Ron. Appreciate that.
You bet. So, and this is probably the one that people are a little more focused on OSHA for. Subdivision 5 talks about high rates of injury. So one of the reasons that this statute was put into place, one of the reasons that when we talk about federal OSHA's National Emphasis Program coming up, one of the reasons this industry's been in the news lately is based on high rates of injury in the NAICS codes. We talked about that type of thing. From an OSHA standpoint, that's our focus, right? I always try and get away from the regulatory piece of my job and speak directly to the safety and health piece of my job. The reason we're here, the reason the statute was put into place is because people are being injured. And this is all designed to try and prevent that, reduce that as much as we can. So, written into subdivision 5, if a particular work site or employer is found to have an employee incidence rate in a given year, based on data reported to federal OSHA, of at least 30% higher than that year's average incident rate for the relative NAICS codes. So being compared to your peers in your NAICS code, if you're 30% above the average for that NAICS code, the statute says the commissioner shall open an investigation. Okay? When it says the commissioner shall, that's us, right? That's us. And so we're not given a choice. So if you're on that list, if your injury incident rate is 30% higher than your industry code, we have to, by statute, commence an investigation. So that's one piece, and we're going to talk a little bit more about that as we go. If you're in that group and you're 30% higher, the employer must also hold its safety committee meetings as required under Section 182.676. That's our safety committee statute. So employers with more than 25 employees, which should be everybody here, right? We've got 250 or more. Ergonomics is 100 or more. But if you have 25 or more employees, you are required to have a safety committee. And that committee will meet monthly until, for 2 consecutive years, your work site is below that 30% over the average number. Okay? I want to go back to safety committees again. Say you're a small employer that's on this call. Okay, a lot of these statutes are for the larger employers. If you're a smaller employer under the call, you have less than 25 employees, you are required to have a safety committee if you're required to have a workplace accident injury reduction program. Minnesota OSHA's AWARE program. That's our health and safety program framework. And there is a list of NAICS codes on our website published that are required to have that AWARE program. And they are actually they're the top half of all NAICS codes. So, you know, in doing that, we kind of line up the NAICS codes and we find out the average incident rate of all NAICS codes, and we take the top half of that. And they're required to have this safety and health program. So, like I said, these NAICS codes are in there because of higher rates or injury. I'm going to take a guess. I haven't looked it up, but I'm going to guess you probably have to have a NAICS code or an AWARE program based on your NAICS code. So again, the monthly meetings, this statute applies to 250 more employees on a site. So that's where this statute applies. So if you're in that 30% higher than the average, you're required to hold that safety committee meeting monthly for 2 consecutive years after you've reduced that rate. Okay, so
yeah, Ron, maybe just before we move on from there, just for folks, let's just review really quick. So the just workplace distribution safety piece, that has a threshold of, you have to have a quota, 250. So there's a size differential there. The high rates of industry investigations, just review for us. Is your department, does it have that same threshold of 250, or are you looking at all warehouses under that? Your kind of your first bullet point there?
The first bullet point is subdivision 5 of the warehouse workers statute. And we talked about employers under that statute in the beginning. They're 250 or greater. I'm going to break down some of the size differences at the end.
Super. Thank you.
And because there's sizes for this, and there's sizes for ergonomics, and there's sizes for other things. So awesome. Bear with me. We're gonna get to that in a little bit.
That's great.
And one question I sort of anticipated here is, how do I calculate my incidence rate? And I'm actually going to touch on that a little bit further down the road too. So if that's something you're looking at, because we've had people call us and say, what is our incident rate? And I'm like, I don't know, that's based on your injury and illness data. So we don't want to calculate your individual rates. Those are submitted to, reported to federal OSHA, and we're going to look at that data, and we're going to use that every year to find out who's going to be on that inspection list. That's not a choice for us, right? That's a statute. Just like, any employer in the state has to follow that, the department has to follow that too, right? We're given that instruction. We've got to come do these inspections. So we'll touch on some of the employee numbers and different things as we go here. So let's just a little summary. It has an enforcement paragraph, and I've been trying to touch on this as we go through. So subdivision 2, which is your written description and your things like that. A to C. D was that adverse action, that type of thing. We talked about that when we went through there, that wasn't OSHA. And then you'll see it jumps from subdivision 2 to 4 and 5. Subdivision 3 was the breaks we talked about. That's our labor standards group. And that says shall be enforced by the commissioner under sections 182. That's the MIN-OSHA enforcement statutes. So just break that down. It's not a huge deal. You don't have to decide who's going to do the regulation of it. Know that the statute's out there and somebody's regulating it. But if you read that, if it creates confusion, that's tried to break that down for you too. So other enforcement tools that have been put into this statute. It does say that an employee aggrieved by a violation of this section may bring a civil cause of action. For many things in the day, OSHA or sometimes workers' compensation or things like that have been what's called the sole remedy. So employees don't have another alternative or things like that. They're starting to look at bringing that back in. And in this section, they've brought that back in. An employee aggrieved by this section can bring a civil cause of action for damages, et cetera, et cetera. And they have 1 year within the date of the violation. That's not OSHA, okay? This is a civil cause of action, essentially a lawsuit. And I'm not a lawyer. I may not even be saying that right, but this is not an OSHA piece. This is another way for an employee to take action if they believe you're violating this statute. Important for you to know, it's not just OSHA. And they put this in there that nothing in the section shall prevent somebody else from being more restrictive, okay? That kind of thing. So those pieces are in there. Again, those aren't OSHA pieces, but they're in there and they allow some additional potential enforcement. So.
And Ron, I think you did mentioning it, but just so everybody knows, civil cause of action, that could be an employee hiring a private attorney to pursue that claim. Just, I know that's not your area of expertise, but just to translate that phrase for folks.
Yep, exactly. So, all right, let's talk about a national emphasis program. So anytime we say national, that's not Minnesota OSHA, right? So this came out of federal OSHA, and I might just touch on that quickly if you're not familiar. Federal OSHA was started in 1970 or so through the OSHA Act, and one of the first things they did was give the states the opportunity to run their own program. Minnesota and about half the other states have elected to run their own OSHA programs. Therefore, I am a state employee. We talk about Minnesota OSHA. We're required to be as stringent as federal OSHA, but we can choose to do things in addition. And that type of thing. So, but when federal OSHA says we're going to have a national emphasis program, states don't have the option of not doing that necessarily, usually. Now, we don't have to do it exactly the same as them, right? We have to be as stringent or equivalent. So, yes, we are adopting the national emphasis program because we've been given the statutes that we've been given this year with this one and the ergonomics statute. We're going to focus on those statutes, and we told federal OSHA that they're going to do things a little bit differently because they don't have those statutes available to them. But we're going to focus on the enforcement of those statutes. What that does mean is we're looking at warehousing and distribution center operations. Now, when I talk about a national emphasis program, you're not going to hear me talk about an employee threshold. Here, I don't care how many employees you have. So we're going to come out and we're going to look at worker safety. Again, why are we here? This is the health and safety aspect. These NAICS codes, your industry has been identified as having higher rates of injuries and illnesses. That's what we're going to come out and look for. If we come out and look and your employees aren't exposed to hazards and you're not having injuries and illnesses, you should do pretty well in an OSHA inspection. But we're going to look because this has been identified. Common things found in some of these industries: powered industrial vehicles, forklifts, there's 1,000 different kinds of forklifts. Other ways of handling materials, storing materials, right? That's what I think you guys do. We'll find out when we get there. Walking working surfaces. This is just slip, strips, and falls, and railings, and stairways, and how are we getting things around? Means of egress. How do we get out of your buildings? And excessive heat. Heat, if you don't know it, has really been on federal OSHA's radar, and they wrote that into this national emphasis program too. So how are we protecting employees from heat, fire protection? These are things that identified by federal OSHA that we should be looking at, you should be considering as we go into this national emphasis program. In Minnesota, we are going to look at the warehouse, in addition to those things, the Warehouse Distribution Workers Safety Act that we just went through, and also our new ergonomics statute, which I'm going to touch on here in a little bit, if those statutes are applicable during the inspection. So if you have enough employees to be covered by the ergonomics statute, if you have enough employees to be covered by the Warehouse Distribution Workers Safety Act, then we will look at those statutes at those times. If you don't, we're still going to do an inspection because you're still in the warehousing and distribution NAICS codes that have been identified as having a higher rate of injuries and illnesses, right? Nothing magically becomes dangerous when you go from 90 to 110 employees or from 240 to 260 employees, right? So while from a legislative standpoint, a statutory standpoint, we pick thresholds where these things are implemented, health and safety doesn't stop and start at a certain employee threshold. So you may still be subject to an inspection, even if you're less than 100 employees or a smaller employer or things like that. So, and then from our standpoint, that's one of the benefits of the emphasis program. We don't have to find out who has more than that or who has between 100 and 250 or who has less than that. We're going to come out, we're going to ask you that question. We'll apply the statutes that apply, and we'll do the inspection based on the hazards that we identify and injury and illness trends that you have at your facility and things like that. So there's a lot of tools out there to help you. Again, federal OSHA puts these out. We don't want to recreate the wheel, so we steer you to OSHA.gov. If you're not familiar, is federal OSHA's website, and you can just type in warehousing, and it's going to pop up a lot of these tools for you. There's an A to Z index. You can go to W for warehousing. They've got you guys in there now. You're going to find some of these tools that can help you identify the hazards that you have and look for solutions. The first one's titled Hazards and Solutions. You can get some idea of what we're going to be looking for. At the bottom, Minnesota Warehouse Workers main webpage. The statute just came to us, right? We just got it. We're starting to build out this webpage. We've got some information there for you, and we're starting to look at some of these things. So, so you can go to that website and take a look as well. Hey, look, here it is. So if you want to take a screenshot of that address on the upper left, that's going to get you there. Otherwise, that dli.mn.gov is Department of Labor and Industry. That's our website. So it goes through and it breaks down some of the things that we have here. I just have a screenshot here. If you go to the page, you can scroll down through some additional information. And there is a page of frequently asked questions that we have included on there. So this is some excerpts, you say that right, from that web page, okay? And want to put this up here for you. You say, well, what is 30% above my NAICS code? Well, here it is. We have this table on our website right now that you can look at and find out what NAICS code you're in, what the average employee incident rate is, and what 30% more than that is. So when you look at your incidence rate, which is computed by the formula on the left, and on our website, there is a link to this incident rate calculator from the Bureau of Labor Statistics. All this data, all this cumulative data, all comes from the Bureau of Labor Statistics. So, and they have a rate calculator where you can go there and take your number of injuries and illnesses, and it'll multiply it by 200,000, which is roughly the number of hours worked by 100 employees in a year. So it's calculating a rate per 100, and then you divide that by your employee hours worked in a year, and you're going to get an incident rate. That's why we can compare a smaller employer to a larger employer, right? That the pure numbers, the raw numbers, a larger employer is likely going to have more injuries and illnesses. So if we look at raw numbers, things don't level out, but we break it down and we calculate a rate, and that way you can benchmark against others in your industry. So this is out there. This is on our website. There's a link to that incident rate calculator, which can help you. I mean, the math is not hard, but the rate calculator actually tells you where to go on your OSHA 300 summary form and things like that. It takes the data from these columns and things like that. So it can help you generate this data. You compare it to where you are on the list. If you come up higher than that column on the right, we're going to come see you. Okay? Might want to think about that and plan ahead. We're not trying to hide that. We're not trying to. We're not going to publish a list of those employers, right? We're not going to put your name on the screen and say you're 30% over. But we want you to know if you're 30% over that industry rate, because we want you to start holding your safety committee meetings monthly. We want you to start focusing on some of these things. And we want you to start bringing that rate down because, again, I always try and bring what we do back to safety and health. We want to find a way to prevent these injuries and illnesses from happening. So hopefully this can help figure out where you sit and how you're doing. And if you're looking good, or maybe you're over the incident rate, but you're below the 30%, the whole purpose of this statute and the whole goal of Minnesota OSHA, and speaking to you as an industry, I'm really hoping that these numbers every year will start shifting down. Okay. So if you thought, woo, I'm only 25% over that rate this year, I'm not going to get an inspection. Well, if hopefully the large percentage of your industry makes improvements, you might be outside of that rate next year. So that's my hope, is that we can shift all these rates down, right? We're not going to get, everybody puts 0 injuries for a goal. We don't always get to 0, but we really want to reduce these rates. We want to get those down there. So if you're not at 30, great, but you might be next year. This is not a one and done. We're not going to evaluate you once and you're on the list or you're not. We're going to check this every year. Okay. We're going to post a new table every year. Yes. I think that's Bobby's question, the TRIR. There are some different acronyms and different things out of there. TRI are total recordable incident rate, perhaps. There's a lot of different things out there. Again, if you use the Bureau of Labor Statistics, it's going to tell you which columns. The biggest thing that you leave off of your recordable injuries, it's really a non-fatal number. So if you did have a fatality, it wouldn't be included in here. The reason is we do a lot of separate calculations with fatalities, and we don't want to double count them. But yeah, we're looking at your total incident rate. So let's talk a little quickly. I know we're coming up here towards the end. I want to leave some time for questions. Ergonomics. So again, warehouse distribution centers. That's again this audience. This applies to you with some friends this time. We've got our meat packing and poultry processing sites, and again for warehouse distribution, and meatpacking and poultry processing, now we're looking at sites. And we say site, that's a specific facility, a site, with 100 or more employees. Okay, so again, you have an employee threshold here. Again, from an OSHA standpoint, we're looking at all employees. We're looking at temporary employees. We're looking at part-time employees. We're looking at exempt and non-exempt, salary, non-salary, all that type of thing. How many employees on that site? Also applies to healthcare facilities. They don't get an employee threshold. Okay. Reason for that is we have had a safe patient handling statute, essentially an ergonomics statute, talking about how they react to patient handling that didn't have an employee threshold, and we're not going to put one in right now for this one. So this statute says DLI, again, that's me, Department of Labor and Industry, will provide training materials about the implementation of this program. We're working on those. We're looking to get those out right away, and actually provide materials for employers like yourselves to use to train your employees. One of the key components of this program is to train your employees. We'll touch on that a little bit more. We're also, if you're not aware, our workplace safety consultation. Now, I'm Minnesota OSHA Compliance. Compliance is your enforcement branch here. We have a consultative branch, and they award safety grants to employers, not just for ergonomics, but it was specifically written into the ergonomics statute that we will provide grants to employers for ergonomic improvements. That's available. That, again, is on our the Workplace Safety Consultation website. So what are we going to do with this program? What are you going to be asked to do with this program? You're going to have to develop a program, and there's some more detail in the statute, to minimize the risk of musculoskeletal disorders. Musculoskeletal disorders defined in the statute, but this is the sprains and strains and repetitive trauma type injuries that are going to come from some of these repetitive tasks, force, weight, the type of movement, good postures, those types of things that happen again. You know, we were just talking about a quota system. How many pieces per hour times, do you have to be on task? Those create these types of disorders. So not only do you, the program is going to require you to assess your hazards. Where are we hurting people? Look at your injury and illness logs. Where are we hurting these people? What can we do? Really assess what's happening. Identify those trends, and then take action to minimize those risks. Implement those things that you can do to minimize those risks and bring those injuries down. Evaluate this annually, right? In your first year, you might focus on this. Boy, this was our biggest trend. Bam, we did pretty good with that. What's next? This never sits still, right? Evaluate that annually, move forward, take the next thing. Keep driving that rate down. We don't talk about it enough, but it is really a very good business practice to minimize your injuries and illnesses. Oftentimes we do this because OSHA is going to come find out that we're hurting people. That's not why we want you to reduce your risks. We want you to reduce your risks so you're not hurting people. Your business is going to run smoother. You're going to have less downtime, less training, less onboarding, less all of these things. Not to mention the direct costs of injuries. I mean, that it's good business practice, and we really want to stress that. We really want you to continue to evaluate and evolve in that program. The training, and this is one of those things that we're working on, developing materials that you can use to train your employees. We want you teaching them what are the early signs and symptoms of this. You want your employees to report early signs and symptoms before you have an injury, right? So you can take action. You can do something else. You can improve that process before it becomes an injury. So you want that feedback. A lot of times employees don't want to share that. They want to be the good employee. They want to tough it out. They want to, no, tell them you want to know early if something's starting to create pain. Pain's the most obvious one in my mind that comes up. You want it at the point of that they're seeing those early signs and symptoms before they're losing time for it, before it's a recordable injury. You know, that kind of thing. That's going to drive your rate down, right? If you intervene before it gets on your list, it's going to keep you from getting an inspection. You want to let them know that you're looking for ergonomic hazard controls. Employees are sometimes the best place to get this information. I didn't touch on it enough when we were talking about safety committees before. That safety committee is required by statute to be 50% employee based, either through labor organizations or, but employees should choose their representatives on that committee. If they won't, the employer might have to pick, but it's not a management committee saying, what should we do about this? 50% employee involvement. They're doing the jobs. Ask them the questions. How can we make this better? Which part of this is causing the pain? Which part of this is causing the struggle? They're going to have good feedback, and you really need to embrace that. As an OSHA investigator during an OSHA inspection, I always ask employees, what's the worst thing you do here? It doesn't have to be a technical question. What's the scariest part of your job? What's the part you don't like? What's the part you wish you could fix? You get great feedback from asking very simple questions. I know they want to work fewer hours and they want to work this and that. And they want to, but they're going to have very, very good feedback on where the pain's coming from, what task is creating that. You need to get that feedback, and that's part of the training that's required to get to them. And record keeping is a big thing. You're going to need to track who's reporting these signs and symptoms, any on-site medical. Certainly any offsite medical, you're likely already tracking work comp and other things. So that record keeping is what you're going to use to evaluate that program. You're going to look at that. Where's our risks? That's the first sign. So improving that record keeping, big part of that program. And we really need to look at that. And it's very much a performance-based program. It's based on your site, because your site might not be like the other site, right? And look at the industries that are in there. There's warehousing, there's meat processing, and there's healthcare. It's not very, specification-based, because those industries are very different. But we want you to assess your risks. We want you to look at where these injuries are happening, and we want you to take action to stop it. Pretty straightforward. It's been very successful. This is modeled after the Safe Patient Handling Statute in healthcare, and they've been very successful in their specific incidents. It's the use of patient lifts and to multiple people, and identifying where the people are getting hurt and implementing these changes. And it happens because it's mandated, and we're really hoping that those industries that are identified in here are identified because of high rates of injuries and illnesses. And we're really hoping that if this program is embraced in the way it's meant to be, that we can really help and work together to drive these things down. So that's it in a nutshell. I only left 5 minutes, but happy to take any questions, happy to go back over anything again. I mentioned to Bruce earlier that I'm happy to come back as we get closer to implementing the ergonomics program, and maybe spend our time in full on ergonomics, something like that. So my information's on the screen. Please feel free and reach out. Bruce, what do we got for questions?
Yeah, I got a couple keyed up here, but I want to take a moment. If anybody wants to unmute their mic, they're welcome to. After I ask this first question. So, Ron, there's some notice requirements in these laws. Specifically, the Warehouse Distribution and Worker Safety Law has the individual employee notice requirements. Are there any macro level sort of employment posters, things that need to be visible to employees? Are there any requirements in any of these things that you just touched on that folks should know about relative to ensuring they're complying with that part of it?
There are some posting requirements from the department. I think one of our website pages speaks to that, but there's an OSHA safety poster, there's a minimum wage poster, there's a few other things. There are no macro type posting things. I took the language in my slides is actually the statutory language in the statute, and so I don't think it would hurt something like that. You may not want to post individual employee data, but maybe there's value in posting that aggregate data, and then if you post it every 90 days, people can, you might get fewer requests for it or something like that. But there's to my knowledge, no macro type posting requirements.
Great, thanks. I'll put in the chat the link to that workplace notices and posters portion of your website, which is really helpful. So I'll pop that down in just a second here. Anyone want to open up their mic and ask a question of Ron? All right, Ron, I got two more for you. One of them came via chat here. It was a good one on the sort of incidence of injury indexing. And I don't know. I think this is a question. So that obviously gets re-indexed every year. And presumably, let's say rates continue to go down, that 30% threshold will still remain in place in perpetuity, right? So your 30%, you may have been under the 30% this year, but as rates continue to drop, that threshold might be different next year. Can you just touch on that again?
Correct. Yeah, I went back to this slide. So let's just take the top one. The average rate for 493 there, general warehousing 5.6, 30% above that is 7.28, right? Next year that could be 4, and 30% above 4 is whatever that is, 4.8 or something. Yes, our hope is that both of those numbers decrease every year. So if you stay still and those numbers go down, next year you might be over 30%. Correct.
Yeah. Thanks for that clarification, Ron. Appreciate it. I'll pause real quick to see if there's any other questions, and I've got a final one. Super. Ron, this is the magic question and sort of a spirit of partnership between industry and the department. And I think what the person that sent it in noticed was that you mentioned a couple times that some of this language was not your language. And I know that wasn't a criticism, that was a statement of fact. As we kind of work together through these laws over the next year or so, is there an opportunity to work with the department on maybe some clarifying changes? There may be things that you see as, that would be a good change. There may be some things that the industry sees as important changes. Just wondering what the process is for working with the department on future changes.
We're happy to communicate and take feedback and things like that. We don't tell the legislature what to do. And just so that people understand, when I'm talking about Minnesota Statute 182, yes, that is OSHA's statute and OSHA's authority, but that is written by our legislature. Okay? And the department has some feedback. And as it works through the process, we're asked questions like, what is this going to do to you? How many people is it going to take to enforce this? And we're in communication with the legislature, so we help to try to guide them to something that will have a good outcome. And so absolutely provide us your feedback, provide us your suggestions. Certainly reach out to your own legislators and lobbyists and things like that. But if it makes sense between all of us, we can bring that up to our commissioner, our legislative liaisons, our people that we respond to the legislature, we go to the committee meetings, we answer their questions, and we do try and testify and be a part of the process as well. So if we're in agreement and language can change or something can change to either clarify or make it better, as long as we both agree it's better, obviously, and in different ways, we're happy to work with that. But I can't make any promises that, that's the commissioner of the department. I work at the pleasure of the commissioner, and I'm not going to speak for her. We try to do the very best we can to work with our stakeholders. Again, I always want to bring the focus back on it's about the safety and health of the employees and the workers. And our previous commissioner was a very good proponent of saying we are the Department of Labor and Industry.
Yeah.
And we want to help them work together and do the best we can for the state of Minnesota. So yeah, happy to work with you. I'm not making any promises, but we're happy to work with you. Yeah.
Thanks, Ron. Appreciate that. I know the folks that I work with, it's in their best interest, and it's their best business practice to keep people healthy as well. And I know we share that goal with the department. So I'm going to stop the recording in just a moment. I know Ron said he can hang on for a couple more minutes, but I'm going to just thank you formally before I stop the recording. Ron, thanks for joining us this morning, sharing your expertise. We really appreciate it. We'd love to take you up on your offer to dive into ergonomics a little deeper as you continue to develop your work there. But Ron, thanks a ton for today and your work with industry throughout your career there, your 25 plus years. So thanks, Ron.
Thanks, Ray.